Thank you all for coming out this morning. Yesterday's ruling didn't change the fundamental argument that I've made from day one, that a governor has a constitutional right to exercise line item veto authority in Texas, and I've used that authority lawfully and legally. Under our Constitution, every citizen has the right to speak their mind freely, without political interference or legal intimidation. This continued prosecution flies in the face of that protection, and it directly assaults the United States Constitution. I am proud to stand for the rule of law, and I know that my actions were right when faced with a public official whose illegal, unethical, embarrassing, and inappropriate behavior has completely tarnished her office and lost the confidence of the taxpayers that she served. And given the choice, I would make the same decision again today. Make no mistake, this prosecution sets a dangerous precedent in our country, and it directly targets the authority of every governor's office in the nation. Legal scholars from both sides of the aisle, they have agreed that these charges cannot stand. And I'll continue this fight, and I'm confident that I'll ultimately prevail, because the prosecution's case amounts to the criminalization of politics, and it would impose a chilling effect on free speech. Now I'd like my legal team to share with you and speak to you about some of the specifics from yesterday's decision. Tony?
Yes, sir. Okay, I'm going to talk to you just briefly about where I think we are, and then I'm going to hand it off to David Botsford to talk about where I think we're going. Yesterday, the judge, I think rightly so, identified major problems with both counts of the indictment. We're very encouraged by that. We think it's just another step in the process. With regard to count one, it's clear that the judge had problems with it being vague and nonspecific. The judge mentioned, as you may recall, that the word veto or threat of veto is not even on the face of the indictment. And the judge encouraged us, and we intend to do this, file paperwork to ferret that out, to flesh that out, because we think once the special prosecutor is required to put that in the face of the indictment, we think that likelihood is that will be quashed. With regard to count two, the judge, as you know, upheld our objection and has ordered this prosecutor to amend that count of the indictment. We don't think the prosecutor can do that. We don't think that he can demonstrate that there is, in fact, that the exception is not met, because obviously Governor Perry, when he issued his veto, was part of a governing body. So we think, again, that part of the indictment is fatally flawed, and we're encouraged by the judge that the judge agreed with us that both counts of that indictment are simply, they just can't hold up under law. And finally, one thing I'd like to mention is yesterday, if you read the 44-page opinion, the judge made the statement that our arguments with regard to the constitutional issues were compelling, but in his view, they were premature. Now, we, of course, respectfully disagree with the judge on that part, and we have filed a notice of appeal on that, and we expect that to go to the Third Circuit Court of Appeals, where we can get that issue decided. With regard to the next steps, I've already told you a little bit about what we intend to file in the next 24 hours or so, but I'm going to let Mr. Botsford talk to you a little bit about the timeline of the appeal and how that process works, so you can know where we go from here. David?
Thank you, Tony. As you all know, we filed a notice of appeal in the Third Court of Appeals here in Austin. That is an expedited appeal under the rules of the Texas Court of Appellate Procedure. That means it will move quickly. Exactly how quickly is up to the Third Court of Appeals, but we anticipate, due to the gravity of the constitutional issues involved, that the court will move swiftly and expeditiously. In the meantime, as Tony said, we'll be filing additional paperwork with Judge Richardson and trying to get him to resolve those other issues while we're doing the appeal. Hopefully this process will take a minimum period of time, both from the standpoint of Judge Richardson considering additional pleadings which we will file in the next 24 hours or so, And if necessary, then the Court of Appeals can also address the constitutional issues which Judge Richardson has acknowledged are very serious issues. Thank you. Tony, pass it back to you.